Good to see you. It's been a
Yeah,
while.
you too. It has been a while.
Yeah. Are you home?
Um, no, I'm in my office.
Okay. I should have worn my tie. Sorry.
I know. I feel overdressed.
Well, thanks a lot for doing this. I really appreciate it.
Of course.
Welcome, Tom Hazelett. Tom is a commercial litigation lawyer and partner at Ballard Spahr, where he focuses on complex business disputes in both federal and state courts. He also frequently speaks on legal issues surrounding emerging technologies and AI regulation. Thanks a lot for joining, Tom.
Thanks, Brandon. I'm not sure how frequently I speak, but this will be an example of me speaking on those issues, so that's good.
Okay, so it's true.
It is true.
Great. So let's start with the basics. For me, what is commercial litigation law?
Yeah, so I think that there's not a universal definition for that, but it's what you hit on in the introduction, which is essentially a business dispute, some sort of dispute between two businesses or multiple businesses.
Hmm?
You are going to sell me product X, you are going to provide service Y, you're going to license certain intellectual property, and when that relationship between two businesses goes sour for one reason or another, or there's just some disagreement that has to be worked through. That's what I think most lawyers would consider commercial litigation.
Okay. So you work at Ballard Spahr. What kind of law firm is Ballard Spahr?
We are a national law firm. We have 18 offices all across the United States. At the beginning of this year, 2025, we actually did a combination with a law firm that was centered out in the Pacific Northwest called Lane Powell. So we now have offices along the East Coast, through the middle of the country in Minneapolis and Denver and Phoenix. And then we now have offices on the West Coast as well. And our newest offices are in Seattle and Portland. We are something north of 750 lawyers, plus lots of business professionals. So I think I'm safe in saying that we are a large law firm that spans the country. We are one of the top 100 law firms in the country in terms of total revenue. And after we've done this combination, we think we'll go up in the rankings. And we do all sorts of things. We do dispute resolution, we do M&A, mergers and acquisition work. We do regulatory compliance work. We do intellectual property law. We do pretty much anything and everything that a large law firm would do.
And what types of cases do you work on specifically? Do you focus on the business disputes or others?
I do. I've got a reasonably broad practice. My practice group within the firm is the Antitrust and Competition Group, which means that we advise clients and we handle disputes that involve competition law.
Okay.
So, for example, when there's an allegation of a company having a very large share of a market and doing things that hurt competition, we advise clients about how to avoid those problems, and we represent clients that are involved in disputes around that issue. Um, I do, again, lots and lots of commercial cases. I tend to do work for clients that are in the life science space or the technology space. I think we'll talk a little bit about my background
Hmm.
later, but those tend to be the kinds of clients that I work on. Um, and but it's not exclusively that. So our firm does a lot of work for large banks and financial services companies. So I do some work in that area. And then the other thing I have going on right now is we're representing some of the Commonwealth of Pennsylvania environmental agencies in defending an environmental regulation. So I've got that going on too.
So backing up just a moment, you mentioned antitrust.
Yep.
Can you give me an actual example of a case that you are working on or have worked on?
By the way, I should say, since we're going to talk about some cases, I should include a disclaimer that I am speaking on behalf of myself, and the opinions and thoughts that I offer are mine, not those of my firm, not those of my clients.
Okay.
Um, I'm currently working on a case on behalf of a company called Corteva, which used to be part of DuPont.
Mhm.
And Corteva specializes in crop protection products, products that deal with pests and fungus and invasive weeds and things like that.
Okay.
Um, Corteva has been uh, involved in, gotten pulled into litigation brought by one of the two federal enforcement agencies, which is the Federal Trade Commission. Both the Department of Justice and the Federal Trade Commission have enforcement powers in the competition in the antitrust area. And in the case that I'm involved in, Corteva is accused of using uh, what are referred to as loyalty programs
Mhm.
to keep competition out of the market for certain crop protection products using certain active ingredients.
Okay.
So what the government has alleged is that by having uh, favorable commercial terms that are offered to purchasers of these products, that Corteva and another company called Syngenta were acting to exclude competition from the market for those particular active ingredients.
How do the loyalty programs actually keep the competition away? So in other words, like there's active ingredients. What does that actually do to the competition?
So there's two issues there that you raised. One is what is the market for purposes of antitrust law?
Mhm.
And there you're looking at, what are the products that could substitute in for the product that's of interest? And so there's always lots of fights in these cases, and you can see it in some of the platform technology cases that are going on now too, that are in the news, about how to define what the competitive market is.
Okay.
Is it just a particular active ingredient? Is it the class of products that deals with a certain pest? How do you define that? And so that's where a lot of the fight comes in, about how to define the scope of the market. The other, in terms of what the allegations are about how these loyalty programs um, work and how they exclude competition, the um, the theory is that they act as essentially exclusivity deals, that they make the commercial terms so favorable that they lock in the purchasers to continuing to buy from any company that has these sorts of things.
Okay.
So there have been cases in the past where through contract you would say you're going to buy exclusively from me this product, this widget that I offer. And so the theory by the plaintiffs in this case is that these loyalty programs operate in the same way, even though they're not phrased as exclusive contracts. They're just that the loyalty programs make them sort of de facto exclusive.
I see. And then how is that actually tracked? Let's say it's not explicitly exclusive, but you enter into a loyalty agreement or contract. How is it tracked if you are purchasing products from another company?
So this is where we the law interfaces with some of your colleagues, which is that in antitrust cases especially, economics experts are a huge part of this case.
Okay.
And they take sales data and they take pricing data
Oh,
and they take sort of market surveys, and you start to perform analyses that look at, can you find relationships between um, some of these commercial terms and market behavior. And then the other piece that oftentimes the economic experts look at is what the impact is on pricing, because ultimately these
right.
cases are trying to get at what is what is the harm, and so you have to be able to you have to be able to quantify that. And so the economists do lots of regression analyses to try to
Okay.
tease out what the alleged harm to the market is from these practices.
Okay. Interesting. So let's talk about your background.
Sure.
So you earned an undergrad degree in biology from
Yeah.
Trinity College. How did you go from biology to law?
Yeah, I have no idea. uh,
Good answer.
yeah. When I knew going into college that I wanted to be a biology major because it was my favorite subject
Okay.
growing up. And I also knew just from family relationships or whatever that being a bio major didn't mean that I couldn't go to law school, that law school doesn't really care about what your undergrad major is.
Right.
At the time, which is a long, long time ago at this point, in the late 90s and early 2000s, um, there was a lot of interesting stuff going on in terms of the biotech industry. The dot-com bubble was forming. There was just lots and lots of excitement around technology writ large. And I thought that using my knowledge and being familiar with science issues and being comfortable with science and technology
Mhm.
in the legal field would be something that would set me apart from a lot of other lawyers that might have been English majors or history majors or poli-sci majors. Um, and so I went to law school and I became a lawyer. And some of that was also because, not in my immediate family, but sort of an extended family, there were other lawyers in our family, and particularly my mom, had always spoken so highly of how great they were and how smart they were, and so it seemed like an appealing career path for me.
And then what drew you to commercial litigation specifically? Was there anything, or was it an organic development, or?
It's pretty organic. You, as a very young lawyer, you kind of get staffed on things as they come in. I think that um, business disputes do offer, and particularly if you have some expertise in your background and you start to do work for clients in the life science area, in the technology area, um, it's a good interface between my interest and some of my background knowledge and what I do as a lawyer.
Mhm.
And so by by handling commercial cases, by handling commercial disputes in a particular industry, um, I am comfortable with. So, for example, if there's an IP licensing aspect to an agreement between two companies, I'm not scared of learning about the technology and learning about the scope of the rights being offered. Um, and and commercial cases are where you see those issues pop up the most.
I see.
Um, I'm not I don't do kind of white collar criminal work. I don't do um, uh, you know, securities law cases, generally speaking, because in those cases, you don't as often get into the the substance of
Oh, I see.
what the clients are doing, what their business is.
Okay.
And in commercial cases, it's much more focused on what are the products at issue, what are the services being offered, what are the license rights being granted, and so you get to learn more about what the
Okay.
client does, which is that's the part that's interesting to me.
So you like the complexity, you like learning about the business context around the case.
Yeah, I mean, I guess I know that I can get bored, and so being able to learn new things as a new case comes in,
Yeah.
that to me was the real appeal of this career path of not being kind of stuck doing the same thing day after day, year after year.
So I think you answered this next question, but do you think your background in science has influenced the way you approach complex legal cases?
Yeah. So one is I don't get scared by a case that has technology involved in it.
Yeah.
There's technology in the underlying dispute. There's science in the underlying dispute. And then the other thing is, so much of what we do is about trying to distill down what's important in a given dispute or a given case. And I think um, what I learned in undergrad and what I learned in labs and what I learned doing some research in my senior year in connection with doing a thesis was how to sort of cut to
Mm.
the key issues and stay focused on the key issues, and that's I think an important skill for any lawyer. So
So you dig deep into these cases. How many of these cases are you working on at a single time typically? How many cases are you working on right now?
I think probably 10 to 15 kind of open matters.
Yeah.
In what I do, we are, on the one hand, it's less predictable than what the transactional lawyers do, the deal lawyers do.
Okay.
Um, those folks, they, they have a closing date. They can work backwards from it. They know when they need to finish a financing or finish a merger or things like that. In litigation, things can pop up unexpectedly. You never know when a client's going to have some issue or some dispute emerge. But on the other hand, there's sort of peaks and valleys in any given case.
Okay.
There are deadlines and rules about when responses are due, and so you end up kind of weaving together your week, your month, your year between your various cases. And some are going to be more active at a given time, and others will be more active at a different time. And you hope that that adds up to being a full, productive, busy year.
Hmm.
But I think it's usually you're talking about a dozen, maybe up to 20 kind of open matters that aren't closed at any given time.
Let's talk about technology and AI a bit. So you recently spoke at IP Watchdog's AI Masters program. First of all,
Yeah.
what is that? What is IP Watchdog and what is their AI Masters program?
So IP Watchdog is a website that started as kind of a blog
Okay.
back when the blogosphere was a big thing. And it's a website that posts about especially patent issues in the law. They track cases, they track developments in the law. They track who's in charge of the Patent and Trademark Office. It's
Oh,
just a news site that is very focused on IP issues. And a couple times a year, they put on these somewhat large panel discussions over the course of a couple days. They do a big patent prosecution panel. And in the past couple of years, they've been doing these series of panel discussions on AI issues. And so last year and this year, I spoke on the panel within the AI couple day conference that was focused on antitrust issues and AI.
what are the most urgent and legal issues around AI right now? That's a big question.
It's a big question. Um, Setting aside whether we will all die, whether something from Terminator is going to happen, which people still sort of jokingly, not jokingly, bring up in these at these conferences. Um, I think uh, the big issue is some of the copyright issues that I think we had talked about, maybe touching on today. There's active litigation about um, um, uh, copyright infringement by a bunch of the large language models that have been trained. Those cases are actively proceeding right now, and people are waiting. A lot of people, a lot of industries, a lot of businesses, a lot of money is waiting to see how those cases turn out. Um, it's potentially hugely impactful on the existing models because to the extent that they were trained on copyrighted material and the AI companies lose on the argument that this was a fair use of copyrighted material, um, that's potentially devastating
Right.
to some of the existing market participants. And it means that they, potentially have to go back to the drawing board in terms of training their models.
So just as an example, we're talking about a company or large language model that's being trained on, for example, a news publication
Yeah.
or books. There's massive amounts of data, and some amount of that is copyrighted material. So the question is, are they legally able to do that? Yeah.
Yeah, that's right. And there's a current case involving the New York Times, might be a
Yeah.
couple cases. There's other cases that have been brought. They have gotten past the very early stages where the question is there like a legally viable theory? And they're into, you know, discovery and exchanging information. And then there'll be trials, there'll be decisions, there'll be appeals. Um, all of that stuff will get resolved in the next, 18 months or so, and
Okay.
there'll be a lot more clarity around this issue. And I think from listening to folks at panels and at conferences talk about this, I think the uncertainty is not helpful to the AI industry. And so whatever the answer is, just getting some certainty around it, I think will help people move forward. And that
Mm.
could mean, I mean, what it will mean doing licenses, licensing access to
Okay.
copyrighted material to sort of have the rights to be able to make copies of text to then train the large language models. And there have been some, you've already seen some of these licenses come out into the market. So I think Reddit did a big licensing deal that the forum, the material in the forums is in the Reddit threads
Yeah.
would be accessible and could be used for training models. And you'll see other kind of large repositories
Mhm.
of language um, enter into these license agreements so that their so that their material is not being copied without the right to do so.
So this sounds like a ridiculously complex scenario. And like you say, in 18 months, let's say it's determined or it's decided that you need a license to train your model on copyrighted material.
Yeah,
Okay. So then the question is, what is copyrighted material, right? There's obvious things, New York Times, Reddit, right? There's others, there's large data sets that are obviously copyrighted. But what about smaller authors who have written one book and they're claiming my book is in the training data? Like, how is that going to be managed? I mean, you're talking about larger repositories. It's a little bit easier to think about what those are. But
yeah,
also, like, how do you prove that somebody's material, which is copyrighted, is actually being used to train the model? Like, where is that
yeah,
information?
yeah. Um, there's a couple issues there. Uh, One is, you're right, the sort of lone author who maybe like e-published a book
Yeah.
or kind of like at home published a book. Uh, that just as the practical reality is that that person's going to have a difficult time. Are they going to be able to find a lawyer that's going to be willing to take a gamble
Okay.
to track down and engage in this? Um, the publishing houses and kind of there are these clearinghouses functions by the publication companies um, that are collective. On the music side, it's what is it like ACAP or whatever. You would
Mhm.
know that better than me, but
Yeah.
um, there are these entities that serve as centralized locations to be able to track published works.
Right.
That's where the action is going to be.
Okay.
Um, I think you're exactly right that the individual author who doesn't have a publishing deal is going to have a difficult time dealing with this. They're going to have a difficult time figuring out if their material had been scraped. Um, that's just they might have a perfectly valid claim as a matter of law, but
Right.
there's practical realities to this as well.
And then there must be gray areas, right? Like, let's say I have a website and I have material, I have content on my website that I wrote. Is that copyrighted? Like, do I own that?
You do the act of putting it down and publishing it gets you. You do have a you do have an ownership interest in that material. The copyright attaches. Um, two follow-up points there. One is for various reasons, if you were to accuse someone of infringing material that you had written for your website, you would want to register that material first. It gets you a greater bundle of rights
Okay.
in terms of asserting a thing. But the act of writing is what creates the property interest. So that fundamental point, even without registering something with the
Wow.
Copyright Office, you still have a property interest in what you've created. The other interesting point that particularly the U.S. Copyright Office is wrestling with right now is what's eligible for copyright. And for historical reasons, the current view seems to be that because copyright is designed to protect the creativity of human beings, material that a generative AI piece of software generates is not copyright eligible. And the US Copyright Office is issuing guidance and also analyzing how to treat kind of a hybrid model where a human being either prompts the AI or takes something AI generated and then edits it. And the question is, where is the line between what the generative AI algorithm generated versus what the human generated? And what the human generated, the expression, the creativity that the human created, that is eligible for copyright protection. There is a property right there that can be protected. But as things currently stand, what the AI created or contributed to the work is not eligible for copyright protection.
Wow, this is crazy to me because like this just seems so difficult to implement, right?
It's really difficult.
Let's say I work for the New York Times and I'm going to write an article. It's easier if I talk about it like that because I work for the New York Times. It's a big organization and their material is copyrighted, I guess. And I'm going to use ChatGPT to help me write an article. Okay, so I start prompting, we're iterating on ideas back and forth. I publish my article. How is it determined the portions of that article which were AI generated versus human generated? Like, how is that even? Are we going to use AI to determine that?
Yeah, maybe you would submit it to some of the academic cheating websites that are out there to see
Yeah.
what looks like it's AI generated
If they
versus
even
human.
work. If they even work.
Yeah, right. If they work, right. Um, uh, it's a really hard problem. The current um, approach to dealing with this issue, and I don't think it's a great one in terms of the point that you just made, is that if you submit something to the Copyright Office for registration, which again gives you like greater rights to enforce and protect from infringement,
Mhm.
you are supposed to include in that submission a statement saying, "This is mine. This is AI generated," and that's supposed to help the examiners figure out, what counts, what is going to be copyright protected and what's not.
Wow.
But it's when it's this amalgam, like you just talked about, it's really, really, really hard. It's really hard.
Could it be something like, let's say you submit an article or a book and you say, I used AI tools to help me write this. And it's probably about 50% of the work was AI generated and 50% of the work was me. Would that be something that they could implement laws around that, the copyright law that says, okay, you own 50% of this, but we're not sure which 50%.
They're not taking that approach right now, and this is part of what the agency has said to the public. Please, submit your great ideas. Please submit comments about what the right policy should be here, because as things stand right now, they are trying to go through the exercise of parsing in a given written piece or piece of art. They're trying to go through and parse. This is AI created,
Mhm.
no protection. This is human created, protection. And it's not, as things currently stand, they're not doing you know, you have 50% of rights because taken as a whole, it's 50-50.
And this must get even more murky when you're talking about like visual art or music.
Yeah.
So is it going to be different? So like I created a logo using AI. I iterated using prompts and I created a logo for my brand. And I want to copyright that. How was the determination made in terms of the percentage of that work that was AI generated versus Brandon generated?
So logo is unfortunately a bad example here because normally you would do trademark protection on a
Okay.
logo, and it's not the same. The kind of
Oh,
human creativity isn't the same consideration there.
okay.
Okay, but so let's go with music.
Okay.
That's a better one, and people get copyright protection on music.
So the question is, I create a song
Yeah.
using AI. But it's the same process. I'm prompting, I'm iterating on ideas, and it gives me, instead of giving me text like an article or a book I'm writing, it gives me a song. I post this song. I say, this song is mine. I wrote this song. I used ChatGPT or some other AI tool to help me, but it's mine. So how is the determination made there in terms of like what's AI generated versus human generated? Is it the same process?
It's the same process as written narrative work that you would have to try to identify, um, and just remember to keep in mind. So for copyright, it is uh, it's the rendering of, it's not the sounds, it's the rendering of the song, of the creativity. So that can be either a recording or it can
Right.
be written, the notes, the recording of the notes. And there it is supposed to be, again, sort of as things currently stand, you're trying to parse through which came from the AI and which came from the human.
Wow.
It's hard. It's
Sorry. Where
it's very, very messy, and that's an area where there's gonna have to be a lot of thinking and testing, and all the industry interests are gonna have to weigh in with how it should come out.
I know we've talked about this for a while, but like, where do you think it's actually going? Like, talking about copyright as it relates to training data and copyright as it relates to AI generated content.
So I think on the copyright issues that are currently disputed, I think that um, it is going to move to a licensing approach
Okay.
because you avoid risk and you avoid fights by just licensing this stuff.
Yeah.
And as a practical matter, the big generative AI companies are investing so much money on the technology side, uh, paying for a license to have
Right.
access to data in the grand scheme of what they're spending probably isn't a huge driver of cost and the cost
Right.
structure. Um, the and There'll be, you know what you're buying. You de-risk the situation that you're not going to have by licensing the data. You're not going to have problems down the road of someone coming out of the woodwork and suing you. And so that um, I think that on the training side and how the companies train their models, they will enter into licenses, they will do some training, and then I think that to maybe fill in a gap in terms of volume, they'll they'll uh, they'll have kind of initial AI models, then sort of generate more text based on the training that's happened so far to get them to whatever threshold they wanna
I
hit.
see.
So
I see.
I think on the training side,
Okay.
that's where it's likely to end up.
The training is more straightforward because it sounds like the licensing is going to be the answer, right? They're not going to go backwards. They're not going to remove data from the training set. They're just going to purchase licenses to continue using that data.
I think that that's likely what's
Yeah.
going
So
to happen.
that actually makes sense, I think, even in terms of like the implementation. But what about the copyright around AI generated content? This just seems a lot more murky.
I don't have a good answer for you.
Yeah.
The the I mean, some of this stuff um, goes to like literally the Constitution in terms of eligibility.
Yeah.
And you see this on the life sciences side that there's this fight over what's patent eligible when, particularly in
Oh,
biotech products.
right.
If you identify some protein that does an amazing thing, there's this fundamental issue of is that patentable? Because have you invented it or have you just like made a discovery of the natural world? Discoveries of the natural world are not that's not an invention. You just
Oh,
figured something out. Um,
you discovered a new combination, right? But you're putting a label on it, basically.
that's the argument, or how it's used. The invention is how something is used.
Okay.
But but in both the patent side and the copyright side, there is this idea of uh, human creativity, human invention is what makes something eligible for the government to grant a property right in it. And it's conceptually, it makes sense. It seems
Yeah.
reasonable, but we're now to a point where what that actually means in practice, given current technology, it gets very tricky.
Yeah. I imagine it's even going to get trickier if you think about the fact that if you use AI to generate content and then that content eventually makes its way back into the training data
That's exactly
to
what's
train
happening.
the same model,
Yeah,
it's cyclical.
yeah, yeah. No, that is what is happening, and that makes it very complicated.
What about deepfakes or unauthorized use of someone's likeness? Like, for example, celebrities and ads.
So, um, there are one of the things I've been saying on some of these panels that talk about AI is that the technology is new and cool, but we shouldn't ignore the fact that there are traditional legal doctrines that still can apply and deal with issues.
Yeah.
And so, you know, rights in your image, like these things, like these idea of false light claims. If you present someone in a false light or try to deceive the public about who someone is, there are claims along those lines
Okay.
already,
Right.
and people have raised that issue, particularly around the deep fakes and some of the like adult material that's been created using deepfake technology. Um, that the public person and sometimes unfortunately the private person they can use these traditional doctrines about
Okay.
casting a false light to address those things. And so that's a case where I guess luckily the law has doctrines and theories that can address problems that this new technology is still creating.
Okay. So this is a little more clear cut.
Uh, Relatively so. I would just say maybe the answer isn't as clear cut, but the tools of what the law allows, um, you don't need new tools to get built under the law. The traditional tools
Okay.
that lawyers have always used can still address this issue.
Okay. That makes sense. Let's talk a little bit about tools and just your day-to-day workflow. I'm just curious, what kinds of specific tools, software, technology are you using day to day to manage your cases?
Um, this isn't super exciting, but
It's okay.
Outlook rules my life.
Okay.
My email inbox and my calendar
Mhm.
are the most important tools that I use.
Okay.
Um, we uh, that's how we communicate. That's how we track deadlines. There's additional software that's very important to the kind of work that I do and that lawyers and large law firms do. Um, uh, Blown deadlines are very, very bad when you're a lawyer. And so lots of law firms invest in centralized docket tracking and deadline tracking software. So on the back end, You have staff that will intake case filings or documents that the parties exchange, and then will input dates and deadlines and follow-up tasks that need to be done. And that gets pushed out to the entire case team so that it's not dependent on one particular lawyer keeping track of things.
Mm-hmm.
We use, particularly for our larger cases, the volume of documents and emails and Teams messages and all the other data that is part of companies' day-to-day operations many years ago became overwhelming to deal with. And so there's specialized software that lawyers use to be able to collect and search and review and exchange the underlying data, the underlying documents that are relevant to a particular case.
Okay.
There's lots of different software solutions. Our firm uses a piece of software called Relativity.
Is that a new?
Relativity is not particularly new.
Okay.
Relativity has been around probably for 20-ish years.
Right.
When I first started as a lawyer back in 2001, there was different software that people used for this function. And then when I was not that young a lawyer, but I had been doing this a couple of years, Relativity came along, and Relativity has become very much a market leader in this space.
And have they, over the last couple of years, enhanced their set of features utilizing AI?
Yeah, so Relativity gained enough of a market share that there became a kind of accessory market of lots of companies building little add-ons and functionalities that you can add to Relativity
Okay.
to
Oh,
customize it. So that's what there is, this ecosystem of sort of supporting and accessory features.
I see.
Relativity itself, over the last several years, this is not super recent, but has used algorithms and machine learning techniques to help identify the more important documents and prioritize reviewing those and getting to those. And then within the last 6 months or a year, Relativity has added an AI functionality to hopefully improve that process of identifying key documents and relevant documents even more. And they've been, over the last several months, they've been rolling out that AI functionality to law firms to use.
Interesting. I'd like to talk a little bit about analytics in a couple of different ways. Predictive modeling. Is your firm doing anything with predicting the outcomes of a case? If you can talk about
Sure. So I would say that as a litigation department within this firm, that's not something that we do as a general course of something that we do on every case. And there's a reason why I'll get to in a second. Personally, I have done this for large cases,
it.
particularly when you are trying to decide or get into discussions with the other side about whether you're going to settle, and to try to figure out what the predicted value of the claims, what the predicted value of the issues are going to be. And so we've done, you do something like a flow chart and you decide what the important issues are in the case, where if you win, you'll get a positive outcome. If you lose the issue, you'll get a negative outcome. And then you do some thinking about what the potential dollar values of the various outcomes will be. And then you do your expected value calculation. You look at the probabilities of the different outcomes. You look at the estimated results, and you add them up, and there's your expected value of the claims in the case. And that can help inform you of where it might be headed. There's a ton of caveats to all of that. The most fundamental caveat is that ultimately juries and judges are human beings,
Yeah.
and their decisions are not as predictable as we would all like to think that they are, or that we like to tell ourselves that we as lawyers can sort of convince them and advocate in front of them to get them to come to a certain outcome. Um, Juries and judges make decisions for a whole bunch of reasons, which don't necessarily tie to what the law is or what the merits of the case are. The positions of the parties, who the parties are, those things can influence what the outcome is. The other thing that's difficult about these kind of expected value modeling of what we do, what I do, is that you're focused on yes, no outcomes,
Right.
and it's really hard to make sure that your client understands that um, this expected value is sort of the averages of the probabilities of all of those yes or no's,
Right.
but ultimately one of these things is going to happen. And so I can tell you right now that sitting here today, this is the average of all the potential outcomes. But that doesn't answer the question of uh, that 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 just doesn't necessarily get you to the answer of what is the right thing to do, because uh, when the case plays out, it's either going to go really well or it's going to go really poorly.
Right.
Um, and making sure that people don't misuse those expected value analytics, and keep in mind the limitations of the model
Mhm.
is something that in the cases where I do it, I always try to be very clear with the client about exactly how much they can rely on it or not.
It sounds like you would go through this process of predicting the value of a claim. For what reason? The reason would be if you want to determine what the expected value is. For example, if you're going to settle, is that the most typical use case of going through this kind of process of predicting the value of a case?
Yeah, I think that is the most common time that you do that, because you're to the point where you're deciding, are we going to move forward or not? Are we going to compromise?
Yeah.
And so I think in those circumstances, it's helpful. People will sometimes do it um, before a dispute, even before a complaint gets filed, before a litigation starts,
Hmm.
to try to figure out, is it worth filing this lawsuit? Because one of the
Right.
inputs you put in there is kind of expected attorney's fees and costs, and
Okay.
for big cases involving big firms, those can be a really significant driver.
Yeah.
Um, and but so um, clients will sometimes want to go through that exercise before a case gets started as well. Um, there are there are there are hedge funds, there are litigation funding companies that are out there that do this as part of their business. They have to do this as part of their business model. Are they willing to invest money in a case? And they so those kinds of companies, I think, as a matter of course, are doing analyses like what I'm talking about,
Okay.
as just a regular part of their business.
Yeah.
But that their financial model depends on those things.
Right.
Our work and how we advise our clients, we're not as focused on achieving a return the way
Right.
some of those financial interests are. So it's different when we do it.
What about judge analysis? Looking at a judge's past rulings on a particular type of case. Is that something you would typically do?
There is information out there. There's this company called Lex Machina that collects this kind of data about judges and can give you
Oh,
summary information about how long do they decide cases, what kind
yeah.
of cases do they handle. Um, I am, I will use that information sometimes.
Yeah.
I am somewhat skeptical. And I go back to the point I made before, which is that um, you're talking about human beings
Right.
having to make decisions um, uh, involving different parties, different facts, different circumstances. How busy are they? Does its judge have a huge criminal trial going on that's going to
Right.
take up a bunch of their time? And so I think it's something to consider, but I personally I don't make it a huge part of my practice and my analysis of cases.
Okay. And then one more area I'm thinking about analytics, and maybe this is just part of the predicting the outcomes of a case that you sometimes do, looking at the opponent, the types of decisions they may make or how they're going to approach the case. Is there kind of a process of predicting what they actually might do? If you say something or you make a decision, how will they react?
So that gets tricky because there's two variables you're considering there.
Yeah.
One is we're lawyers, we're attorneys, we're agents, and so we're acting on behalf of our clients.
Yeah.
And so you can have a good understanding of the types of arguments that
Yeah.
either an opposing law firm is or an opposing lawyer is, or what kind of person are they, how do they perform, what's their demeanor, what's their approach. And that might not be what you see in a given case because their client is demanding something different or the situation demands a different approach.
Yeah.
Um, there's a similar situation where clients, mm, you know, uh, there was this whole huge wave of litigation involving patent trolls, these companies, these entities that would go out and either develop or acquire patents on various technology. There was a lot of this going on in the wireless technology space.
Okay.
Um, and these non-practicing entities, these patent trolls, would go and buy up patents from individual inventors or failed companies, and then they would bring bring claims against large technology companies to try to sort of cash in. So you can have an understanding of that kind of company and what it's trying to achieve, but their lawyer might be different, and so you have to you have to take both of those things into consideration, and it makes it tricky to really peg your approach to what you think the other side's going to do.
There's something I'm thinking about. What advice would you have for someone who is interested in getting into commercial litigation?
I think what I tell law students and even people in college is you want to envision what it is you want to be doing in 15 or 20 years,
Hmm.
and then think backwards from that. I think that law school is really good about training people's brains to identify issues, to think clearly, to write clearly. Um, and then you start practicing law, and there's all these other skills that you need to develop or have, and talents that you need to have to be a successful lawyer. And so, um, starting by picturing in your head, what is it that I really want to do here? And then thinking about the path that you need to take to get there is is important. You don't just sort of uh, get on the conveyor belt of I'm going to go to a good law
Okay.
school. I'm going to have a great internship at a big firm. After my second year of law school, I'm going to join that firm, and then I'm just going to go and go and go. There's lots of people that start down this path and they get burned out, or they feel like this wasn't what I signed up for, and they drop out, and that doesn't serve them. That doesn't serve the law firms that they join. Um, there's no reason for it. So sort of think about what the goal is, and then figure out the right way to get there. And then and then talk to people. Talk to people that are in the position that you want to be, and figure out what they how they got there and what they did, and try to keep that path in mind as you're trying to achieve the same end result.
You ready for the lightning round?
Sure.
30 seconds each.
Okay.
A recent case or topic in tech law that you're following closely.
Yeah, we touched on this a little bit, but there's these antitrust cases against Meta involving acquisition of WhatsApp and Instagram, and then there's 2 cases against Google. There's the search case and the ad case. All of them are antitrust cases. All of them are allegations that Google and Meta harmed competition, either by acquiring these other services or by growing and locking in such a huge market share. I think lots of people, particularly in the antitrust area, are keeping an eye on those 2 cases. And on the Google side, what the remedy is going to be, because there's already been a finding that they were acting as a monopolist. So figuring out what the remedy will be, I think, is something people are interested in.
One legal doctrine or precedent more people should understand.
Don't send dumb emails.
Oh,
It goes back in all of the law books and all of the highest courts in the land. But
should you assume all email is public, that everyone can read your email? Is that a good way to go?
that is a good way to train your mind to avoid saying stupid things. Yes.
One tool you can't live without.
My Outlook calendar, my calendar on my phone tells me where I need to be. I joke with my spouse that if it's not on her calendar, it doesn't exist. So.
Favorite band right now?
It's been my favorite band for a long time. It continues to be my favorite band. It's this band called Mogwai from Scotland.
I know them.
They have a new album called The Bad Fire, which was made back in the winter, and yet somehow, even though it's referring to the bad fire, it feels optimistic and feels bright in a way that I kind of need right now.
I just found it on Spotify. Thanks for the recommendation.
Sure.
Favorite non-legal hobby or interest?
I'm sure this is shocking, but I like to read. And I've been trying to read more books and less social media lately. So
we should all do that. Coffee or tea?
Obviously coffee.
Obviously. Thank you.
Thank you.
This was great. I learned a lot.
I hope so.
Yeah.
Thanks for inviting me.
Yeah, this is fun.
All right. Talk to you later.
Thanks.
Have a good weekend. Bye.